Good morning, participants, to this workshop on roles, responsibilities of IPs and IRPs. I, Surbijan, welcome you all on behalf of ICSI IP in this workshop, and we have with us the eminent faculty ICS and IP Madhusudan Sharma sir. I would like to read his brief profile before all the participants. He's practicing as an advocate, mediator, and insolvency professional FCS, FCMA with 40 years of diversified job and consulting experience in public, private, and cooperative sectors. He started his career with National Dairy Development Board, Anamur. He has been the consultant advisor in urban infrastructure projects in Bhutan, Nepal, Tamil Nadu, Jammu and Kashmir, Smart City, Amrut, funded by Asian Development Bank, World Bank, and others. As a consultant, he has been associated with consulting companies like Louis Berger, Wilbur Smith, Scott Wilson, ICF, and GHP. He's been the guest faculty for IBBI, Insolvency Professional Agencies of ICAI, ICSI, and ICMI, Indian Institute of Corporate Affairs, National Institute of Banking Management, School of Planning and Architecture, New Delhi. It's been a privilege for us, sir, to have you in this workshop to deliberate on the topic roles and responsibilities of IPs and IRPs. And over to you, sir, for this session.
Thank you, Surbhi, and thanks to the Institute for this opportunity to interact with the fellow professionals. Good morning and welcome to all the participants.
Morning.
Since the topic is of very importance to the professionals, I'll request to put the video on and interact so that we learn from each other's experience. If otherwise it is not inconvenient for you to put the video on. It's a very sensitive topic, very important topic, and this decides the future of the professional, whether to continue in it or whether to enter or not to practice this profession. So before we start about the details of the roles and responsibility of an insolvency professional and the disciplinary cases, recent ones, we would like to deliberate on the ecosystem in which we operate, because everything will depend on what the environment we are in, how we are supposed to behave or how we are forced to behave. So the first thing is what the IP is supposed to do. Over a period of time, ever since IBC was notified, the role and responsibility as put in the code, the regulations, and as per the judicial pronouncement has been changing, and it is becoming more and more demanding. More reporting, more compliances, additional regulations, strictures passed against the insolvency professionals by the adjudicating authority at the slightest indications or slightest complaint about it. So when we discuss about the ecosystem and the very basis of why the IBC was notified, things will be clear to the extent that how careful the IP has to be, how challenging is this profession. What I feel and what I witnessed in the initial period of 2016 and 17, when a lot of professionals were attracted to become IPs, one of the features was that schedule given in liquidation regulations. You remember which is that schedule which might have attracted a lot of people? Yeah. One schedule in the regulations liquidation.
Table, regulation 3B.
The table is regarding the fee.
That's right.
But unfortunately, the ground realities are quite different.
Yes.
There are situations because you can't directly jump to liquidation. You have to go through the process of CRP. And in the CRP process, it is highly uncertain as whether the IRP gets a fee or not. Of course, over a period of time, most of the people who joined initially have stopped practicing the profession. They are again focusing on to their main professions. So it depends on the personal qualities and the risk which one is ready to take, the challenges which one is ready to face in this profession, they continue. So why we got into this trap of NPAs and why IBC was brought into picture? Because of the lending scenario in the country. And who are all involved in that? The borrower as well as the lender. So we can't find fault only with one party. In fact, the whole system was responsible for the situation of NPAs. Everybody contributed. Maybe the degree of contribution was different. But unless there was a lender who was ready to lend without checking the credentials or without having an effective monitoring system, how the borrower could have taken it. And if the regulator or the government was very, very efficient or like the monitoring system was perfect, the things would not have gone to that extent. Of course, there are instances and you can't control delinquencies, but it could not have gone to that level. And when a corporate debtor is admitted to the insolvency process, there are different stakeholders, and the interest of each stakeholder is at the crossroad. And that's the most challenging situation for an insolvency professional. IP has to work as per the guidance of the law, the guidance of the regulator, take care of the interest of all the stakeholders. Others balance the interest of stakeholders without much of an authority regarding that. There are certain unique situations for this profession as compared to the other base professions we belong to, like advocates, CS, CMAs, CA or engineer or a management professional. So what are those uniqueness as compared to other professions that will facilitate us to understand the challenges and how we should cope up with it and how should we function without inviting the rigors of disciplinary action from the regulators? Anyone? I think all of us are IPs and fairly acquainted with the profession.
Yes, sir.
Yes, please. How would you differentiate this profession from other professions? A few prominent points.
Yeah, the first point I would like to say, this profession requires a lot of compliances. Besides handling the role as an IP, as a running operations CEO of the CRP company, you have to additional compliance burden, very, very, very high, higher than the other professions. That's what my understanding.
In fact, IP has to work like an entrepreneur. That approach is very much needed for having the successful IP career.
Yeah, I would like to add something here. As an IP, apart from your core expert professional area, if you're a company secretary, you need to have the knowledge of the IDT, DT, other compliances, the sector in which the company is operating, that sectoral compliances. If the company is in real estate, then what RERA means. So I think multidisciplinary approach is required in this profession.
Any
Of
other
activities is also there, I think.
Yeah, in other profession, we have an independency to take decision. But here also there is independency, but so many restrictions are there. and we are need to worry whether any show cause notice or anything will come. That hindrance is there in taking any decision, though we are working in the interest of all the stakeholders. So this is very much bothering area of, this is
That,
for me, I am telling.
that fear is constantly there in
Yes,
the
yes,
mind
yes,
while
yes,
working.
yes, yes,
That is
sir, yes,
ability
yes.
to take a tension, reduce the tension actually. Means we should not take any, if any, because daily there is a target, there is a, daily there is some notices, daily there is some strictures. So one who able to withstand this whole pressure, then he can take, otherwise end up with health issues.
Sir, he should be an all-rounder, sir, having knowledge in all fields, whatever are there. I mean, right from general laws, where some general common sense is required and beyond.
He
Yeah,
should be, he
though
should-
we are working in interest of the stakeholders and aim to achieve the motto of IBC,
Mhm.
still there is a fear in every time of execution.
Yeah, he rightly said actually all-rounder basically. You are supposed to work like a CEO, but in every company, CEO works like what he thinks best. But here you need to think from IBBI perspective, NCLT perspective, other legal professional perspective. You have to check with the lawyers also. So it's a CEO job, but not like exactly CEO. You have to, there is a ring fence around you. You have to move in between the, round. You can't go beyond
Sir,
in
work under the
not in a like
supervision.
normal CEO situation. But you are supposed to do, they say basically you are CEO of the company, but there are a lot of restrictions over here.
Sir, we have to work under the supervision and vision of many agencies, sir.
Yes, yes. And over compliance is the main issue. If you have,
So you should be like an IAS officer.
yes.
IAS officer can become head of any institution, irrespective of the background knowledge or the professional competence or professional knowledge. So one is expected to be like an IAS officer without the accompanying rights and authorities of an IAS officer. So that is one thing.
First of all, the powers with the RP, it is defined, it is said, but when he executes it with a good intention, it is not taken in the right perspective by the other side of the coin. Any stakeholder for that matter, whether it is corporate debtor, whether it is NCLT, whether it is IBBI. See, nobody looks at the ground reality at which the RP is working. First
Yes,
of all,
sir,
that
exactly.
that is missed out by all the agencies who are working in tandem with the RP. This is my humble opinion.
That's why.
Very true, sir. Very true. Actually, in one of my case, for the
Mhm.
last 3 years, there is no COC happening, and you will be surprised that the income tax department is the COC member holding more than 99%. And even I got the order against Commissioner of Income Tax, but still no result.
So that was the reason why I exactly started with about the realities of our ecosystem. So what is happening?
So, pardon, sir, pardon. The CD is least cooperative, sir. He is not giving any data. Even 19.2 section application, they are not being decided for years together. So you are working without getting any information. Whatever information you are getting from the banker or from public domain, with that you have to execute the transaction, and entire burden is on RP only, sir.
That's a satire. In short term, you can call it's a satire.
Yeah, because 19.2 application should have been decided within a week or two, and it is not being decided for years together, sir.
Yes.
And ultimately, the court tells you take the help of the local police. Under what section we have to approach the local police after 2 years, 3 years?
IPs are regulated.
So when we start up discussing about the problems are unending, and that shows the challenge within which we are working. Our situation is like a soldier having a lot of weapons, but the trigger has to be on the command of somebody else. So if you are facing a terrorist and you wait for the instructions to start the combat, what is your situation? The same thing is for the IP. He is equipped. The law provides him a lot of protection. He is authorized. But as some of you rightly pointed out, he has to take care of the multiple considerations before starting his action. Otherwise, the soldier, he has an authority. If there is an enemy and he faces threat, he is authorized to take action, whatever he can do. But that situation is not there with the insolvency professional. Let us briefly summarize it. The corporate debtor will never cooperate with you because the corporate debtor in 90% cases has fraudulent transactions or had related party transactions or siphoned off the money. So cooperation with the IP will bring problems for him. That's why, take it for granted, the CD is never going to cooperate in most of the cases. There could be 10% genuine cases of business failure where there is a desire to resolve and the corporate debtor or the management may cooperate with you. The second aspect is the committee of creditors, which has been given more powers as compared to IP with lesser responsibilities or lesser teeth to nail them if they are doing something wrong. Because IBBI's domain for regulation of COC is not backed by any law. The regulator is RBI or other regulators, and IBBI could hardly do anything on that aspect. And the very reason that we are in a scenario of NPA is the approach of the lenders, which is now this committee of creditors. And at times there is a conflict between the IP and the COC regarding the key decisions to be taken for the corporate insolvency resolution process. Unfortunately, we have judgments from even the apex court saying that the commercial wisdom can't be tinkered with. So the COC has unquestioned right to decide on the commercial issues. On the other hand, the RP who is supposed to take the company out of insolvency, supposed to bring a resolution, is bound by so many parameters, so many authorities, and even his decisions are subject to the approval of the committee of creditors. When it comes to the other stakeholders, every creditor would like to have the maximum return out of it, because nobody would like to leave the money if possible. So there are pressures from all the sides. You will have pressures from the employees, the promoters, statutory agencies even, like despite so many judgments by the Supreme Court saying that once the resolution is approved, the new management is protected and you can't have a claim, section 32A, but still there are authorities which will file cases and which will have this investigating process started against either the RP or against the new management. So it's very difficult to control the environment in which we are there. And the key problem is the lack of governance. Of course, we talk a lot about governance, but every aspect of the stakeholder is, you will find that there is big gap in the governance. On the other hand, if you see the code of conduct of insolvency professionals, it is very difficult to survive complying with all those code of conduct ethics. All restrictions are on the insolvency professionals. So why I'm bringing out these things to the fore is that when we are entering this profession, we know the reality, ground realities, so we should prepare ourselves, equip ourselves to work as per the law. And if we find that, yes, we lack somewhere, so what is the option? Either to update the skills, prepare for it, or to exit.
Madhuji,
Otherwise,
Yeah,
Yes.
see, so the 2 points which you made, I want to just contradict that very, what you call, with deep thinking. You said the COC, IBBI cannot control. They are governed by RBI, okay? RBI controls the banking function. RBI doesn't control the insolvency function. Bankers are coming here as a COC member, okay? So they are not under control of what you call, so far as it is relating to insolvency or their conduct under IBC, it has to be governed by the IBC. This is a complete misconception which has been spread, and IBBI is teethless, or say they are not what you call strong enough to take a right action. Otherwise, if IBBI doesn't have control, how they can provide all these regulations where COC has to do this, COC has to follow this procedure, and then should be the way or of RFRP and everything. It is simply ridiculous. If COC cannot be controlled, how IBBI prescribing the procedures? That is to be followed by the COC. So it is not about that. It is not the banking function which IBBI is doing.
No, that's true.
Again, the commercial wisdom is only for approving the resolution plan.
May I know who's speaking?
This is Jitendra Jain from Mumbai.
Acha, Jitendra. You are right, but we will just see some of the.
No, this is a misconception which IPs have to raise. We as a IP have been punished and everyone is fooling for their vested interest. Again, the commercial wisdom. What is the commercial wisdom? It is only for approving the plan. In the guise of commercial wisdom, COC cannot override the specific provision of IBC rules or regulation to take over the power of legislature. So this is all rubbish, and it is the weak IPs and IBBI who have been fooled and they are not taking action. I'm so sorry to say that. And as you rightly said, exit is a better choice than anything in the present circumstances.
So coming back to that regulation part, you rightly pointed out that it has to be done, but it is not being done. You see number of recent disciplinary cases where IBBI has come to a conclusion that the conduct of COC was not proper. They have misused the concept of commercial wisdom, but they have not been able to put any penalty on them.
That is the problem with IPs. Whenever IPs are going in the High Court, one has to understand the conduct of IBBI official and IP is protected under the same section 233. They are governed by the same rule. If conduct of IBBI officer is like this, if when IP is filing writ in the High Court, they have to make them a party and they have to tell them your conduct is also as bad as mine.
Okay, we will come to the details later on. The idea was to have an overview of the system in which we are operating, the realities of the system. And the question I posed was that what is the big difference between IPs and the other professions? Some of you have articulated a number of differences, but I would like to still bring out some of the points which you missed. The first one is this profession has two regulators. There are two regulators. You don't find two regulators in any other profession. Which are the two regulators? IPA is a second level regulator and IBBI is the first level regulator.
And on top of that, we don't have any representation in station. Otherwise, we have representation.
Please allow me to bring out the differences.
Why are not including the NCLT? They are also regulating the IPs.
Just a minute, please hold on. Let me complete what I wanted to say. And unfortunately, in one of the cases, Honorable Chennai High Court has upheld the concept of two regulators. They said there is nothing wrong. The regulation, a profession can be regulated by multiple regulators. So that has been rather fortified. Now, the second thing is every regulation has its own body to regulate, like the CA, CMA, CS. What is happening? The body which is regulating the profession is Insolvency Professional Agency. And this agency, of course, there are members appointed in various committees, but this is not a self-governing professional body. So that is the second difference. The third one is, normally when you take any professional assignment, you are not interfering or you are not responsible for the management of that client. But here you are acting as a profession and you are saddled with the responsibility of managing it as a going concern entity. So you are in a dual capacity. You are occupying a statutory position. We are called as court officers. And you are also managing the day-to-day affairs of the corporate sector. So that becomes a very, very different requirement or challenges for this profession. And that's why one has to be very, very careful before taking up the assignments. Another aspect is regarding fee. Initially, the concept was that it has to be market driven. And if you see the BLRC report, it is made very clear that the fee has to be in the public domain so that the clients, prospective clients can decide who has done what and what the fee he has charged. But it was very late. This started getting on the IPA portal. Initially, that was considered as something confidential or it was not disclosed. And there is uncertainty about the fee always. It depends on the whims of the COC and the adjudicating authority. There have been a number of cases where the adjudicating authority and the appellate authority has been taking arbitrary decision about fixing the fees of the insolvency professional. In many cases, they have even reduced the fee which was approved by the COC. And in that case, there is a very good judgment of Honorable Supreme Court protecting the fees of the professionals. One is in the case of Alok Kosik, and another based on this judgment was Mr. Devrajan's case, where the apex court has criticized the way fee was decided by the adjudicating authority. And they said it has to be based on the facts, based on the details available. It can't be arbitrary. And it was sent back to the adjudicating authority for deciding. So we have silver linings as well as negative outcomes of the various judicial pronouncement. And the things keep on changing at different points of time, like the rules and regulations. So the IPs are always in a state of alertness as to what they should do, what they should not do. Another restriction, when we talk about the corporate data, we say free entry into the business, free running of the business, and free exit. But for the IP, that free exit option is not available. Even if he is not getting paid the fees, even there are many cases where the COC decides to replace the RP, but either they don't file the application or the application lingers at the level of adjudicating authority. So for a long period, the IRP, despite having a decision from the COC that he'll be changed, he continues to perform. And the law also says that until the RP or another RP takes over, the IRP or RP has to continue discharging all the responsibilities. As far as the standards of ethics or standards of requirements in terms of compliance is concerned, again, there is a big gap. You have rightly pointed out the compliance burden is increasing day by day with every non-compliant or in any of the investigation or inspection or disciplinary committee findings, the rules are fortified. And that's the normal bureaucratic approach, because whenever there is something wrong, they will try to make very stringent rules and regulations so that all the masses comply with that. Same thing is happening with the insolvency professionals. My personal view is that whenever there is non-compliance done by the IP, that particular IP should be penalized to the extent possible without increasing the burden of compliance on the whole community. But unfortunately, that's the way the government operates. So that's how we are seeing that number of forms to be filed increasing from IP1, CRP1 to 8, and maybe more compliances will continue. So with that background of the challenges, we will discuss or have an overview about the responsibilities. Of course, we'll not get into the details of each and every aspect, since all of you are insolvency professionals and carrying out the IP profession. We will just have an overview about the situation, and then in the last, we will see about the disciplinary cases, recent disciplinary cases, how things move. I'll just share a PPT. If anyone has any other issue related to the few topics which we discussed, they are free to express their opinion.
Sir, your voice is a little low. Could you please increase it?
Okay, I'll bring the laptop closer. Now is it okay?
Yes, sir.
So let me share the PPT. So just please confirm the PPT is visible.
Not yet open, sir.
Not yet open. I'll do it again. Systems.
Yeah, it's okay.
No, okay, thank you. Which of the two you will choose? This one or this one? Can we manage without this? See, the very purpose anybody is into a particular profession is to have its sustainability. So money is necessary in the form of fee, but legitimate money, not otherwise. This indicates that despite all the negativity of the ecosystem, how the IP has to behave. Like lotus in mud. We should be devoid of all the attachments related to the negativities of the ecosystem. And the drops on the leaves indicate the transparency required from the insolvency profession. So it's really a challenging and difficult situation where this is very uncertain. We are supposed to be like this, but we are not sure of getting this. So most of the DC cases where you get negative comment or observation on the performance of IPs are centered around two key objects of the IBC. That is, wherever there are delays or whenever there is a likelihood of decline in the value of the assets, or if there is loss of value of the corporate debtor. So that object of time-bound resolution and maximization of the value of assets are at the key as the keys or the central points where the performance of IPs are being monitored. This observation of BLRC is relevant to the present situation where we feel.
So voice not clear, sir.
Okay. This paragraph, second paragraph, which was from the BLRC report, is very important to the situation which we face about the compliances. What it says, a well-functioning system of resolution driven by IPs enables the adjudicator to delegate more and more powers and duties to the professionals. The worse the performance of IPs, the more adjudicator may need to personally supervise the process, which in turn may cause inordinate delays. And that is what exactly happened. Because of the deeds of a few fellow professionals, the whole profession image is tarnished and stringent regulatory processes are introduced because they don't trust the profession. And that's how we have seen how the regulatory or compliance requirement of insolvency professionals has increased over a period of time. We talk about the 4 pillars of the profession. The first pillar, the adjudicating authority or the regulator IBBI, and the information utility and the IP. Now, if you compare the 4, the IP is in the most disadvantageous position as compared to the other. Adjudicating authority is on the top of it. IBBI is a regulator, is again a government body. Information utility, there's only one information utility, which has its monopoly and they can decide their own prices. So out of the 4 pillars, IP is considered to be the fulcrum, the most important. But otherwise, it's the most weak pillar in terms of rights, in terms of the remuneration, in terms of the authority. Now, these are the various roles which the IP can take. We can skip this. Some of these we have already discussed. The IP exercise the power of the board or director, vested with the management, is a custodian of the property, manages the company as a going concern, and these responsibilities require the highest level of integrity, reputation, and character. I'm just highlighting the key responsibilities of the IP, which are a big challenge. Taking over control and management of the CD, the biggest challenge. The RP of one of the very large CD under insolvency categorically made a remark. Though the law requires the RP to take control of the corporate debtor, even in a small sized corporate debtor, it's very, very difficult for the RP to take over everything, particularly in the small family managed units where the things are dependent on the promoters. So this is a big challenge which the insolvency professionals have to face. Verification of claims, organizing and managing the committee of creditors, interim finance, valuation. I'm just quickly running through this to have a broad perspective for discussion. Preparation of IM, where the CD is not cooperating, the documents are not available, the records are not available, expression of interest for resolution plan, disclosures to IBBI, and reporting to NCLT, IBBI, and IPA. So a lot of reporting requirements in terms of compliances. Now, out of all the duties, these 3 key duties decide the fate of an insolvency professional or broadly highlights the challenges. So one is compliance with the requirement of any law. The second is to protect and preserve the value of the corporate debtor. And the third is continued business operation. Because the value depends on the continuity of the business operations. And if the business operations continuity is affected, the value will go down. So these are the three most challenging duties and responsibility of the insolvency professionals. And if he or she carries out these three functions effectively, is the hero or the achiever. But it's very difficult to achieve all that in the given frame of stressed corporate debtors, which the IP is to manage. And on the top of it, Section 28 puts a responsibility in you that key financial decisions are to be prior approved by the committee of creditors. Of course, IBBI has come out with a chart of responsibility where it has listed section-wise as to where is the responsibility of RP and where is the responsibility of COC, or in which cases there is a combined responsibility of the COC as well as the RP. So that chart is available from IBBI. The key issues faced by the IPs are appointment and exit. The first challenge an insolvency professional has after registration is how to get an assignment. And that is the source of all the problems which the insolvency professionals face. Because at times, in the anxiety to get an assignment, they compromise on certain things. And that compromise leads to a lot of issues during the execution of the insolvency resolution process. Either the RP comes under the pressure of appointing committee of creditors, or delineates or deviates from the path of responsibility by the insolvency professional. So this is a big challenge in this profession, which is continuing ever since IBC was notified. And with now the IP entities being allowed to take the insolvency cases as IP, the things are becoming more difficult for individual insolvency professionals. Sustainability of IPs in terms of the fee, quantum, payment timings, and the litigations. Even after the resolution, the IPs face litigations because any interested party or any of the stakeholders can file application before the adjudicating authority or appellate authority, or even up to the level of Supreme Court. This is the framework of law which regulates the insolvency professionals, starting with the Insolvency and Bankruptcy Code, several provisions. Then, empowered with the code, IBBI has notified 4 sets of regulations which are directly concerned with the functioning of insolvency professionals. One is IP regulations. Second one is grievance and complaint handling. The third one is inspection and investigations. And the fourth is insolvency professional agencies, because that's the second set of regulator. So all those 4 sets of regulations and the provisions of IBC govern and regulate the functioning of insolvency professionals. This is again just an overview of the provisions of the code dealing with the duties and responsibilities of the IP, either in the capacity of interim resolution professional or as RP. There are similar provisions regarding the duties of liquidator, but that we have not included here. These are some more provisions regarding complaints, inspection, investigation, show cause notices, appointment of DC, punishments, directly on contravention by the IP and for any other provision contravened by virtue of the residual program additionally introduced section 235A. Section 236, trial of offences by special courts. The definition of RP includes the IRP. Because at times we use the word IRP or RP, that confuses. So we will use the standard term RP that will include the insolvency professional. Now this is important. Section 208, where an insolvency resolution, fresh start, liquidation, bankruptcy process is been initiated, it shall be the function of an IP to take such actions as may be necessary in the process. So that covers all the processes. And the most important is the section 2082, which is the source of all regulations relating to the performance or functioning of insolvency and insolvency professionals or the resolution professionals. Here there's a provision that IPA can inspect the records of insolvency professionals. Section 217218 talks about the inspection and investigation. The provision in the code that is for the Insolvency and Bankruptcy Board of India. This we have already seen. This is the key provision based on which the penalties are imposed by a disciplinary committee. And what the disciplinary committee can impose is a pecuniary penalty or in terms of suspension or cancellation of the registration. There is a judgment of Honorable High Court of Jharkhand, which is now under challenge before Honorable Supreme Court, where the resolution professional has been considered as a public servant. Though under IBC, the protection to the insolvency professional is to the extent of their bona fide actions. And to that extent, they are at par with the other officers of the IBBI or the government, but it has not been considered as a public servant. But the Jharkhand High Court has interpreted the provisions of Prevention of Corruption Act. And by virtue of that, it has held that RP comes within the meaning of a public servant under Section 2C of the Prevention of Corruption Act, for the reason that the definition of public servant as given under the PC Act is very wide and expansive. It is not limited to those serving under the government or its instrumentalities and drawing salary from the public exchequer. So it is not limited to these three categories, which otherwise is the normal perception about a public servant. So let us see what is the outcome when the Honorable Apex Court decides about it, whether RP is a public servant or not. Another important judgment of Honorable High Court of Gujarat is regarding the constitution of the disciplinary committee. And this is on the interpretation of only one word in the section, which says that members, section 220, subsection 1, there is a proviso which says that provided the members of the disciplinary committee shall consist of the whole-time members of the board only. So the Honorable High Court has interpreted this, that the DC committee can be of more than one members. There has to be at least more than one members. And here the decisions of the DC, which was constituted only of a single member, have been challenged and stayed. The DC shall consist of the full-time members, and hence it could be construed as comprising of at least 2 full-time members. Whereas in the facts of the present case, the quorum comprises of a single member, hence submitted that the said order be stayed, and the High Court had stayed that order. Other High Courts have also stayed orders of a single member of the DC, except Delhi High Court. Delhi High Court is not granting a stay. So again, the matter will be crystallized when the Supreme Court decides on this issue. So far, any observations of the participants or any queries? Because it is becoming a monologue, one-sided discussion.
If the IP is included as a public servant, PS, then it would be all the most dangerous for the profession.
Yes, because this is under Prevention of Corruption Act.
I know what it is.
So I remember in the initial period, 2017-18, people used to discuss that why we are not considered as public servant, why we should not be, and why we should not get an ID from the government or the IBBI. So any tag comes with a responsibility, which one should be ready to share. Any other queries or observations?
This is about this thing that it should contain at least 2 whole-time members. Has this been now put into practice? Because at least till April, and I myself got a SCN, there was only 1 member.
Yes.
Who dealt with my SCN.
You see, and the problem with the our judicial system is that if you agitate an issue, they give an order on that issue. So here, the IPs have approached the High Courts to put a stay on that particular order. So there has been a stay on that order. But as far as the wires of the code is concerned, Supreme Court in Simon Waters case and even in Lalit Jain case has directed all the High Courts that they should not consider any writ which is challenging the wires of the code. That should be transferred to the Supreme Court. So ultimately, when it is agitated before Supreme Court, then only it will be decided and the final result will be available. Because generally, the High Courts are not getting into the wires of the code provisions. It started with the Swiss Rebel, where a lot of issues were challenged, and Honorable Supreme Court upheld those provisions. Of course, there are instances like in Univalue project case, when NCLT issued a circular saying that henceforth in Section 7 application, it's the record of information utility which only will be considered. And with that, they also said that in the existing cases also, the applicant is required to submit the record of information utility. So that circular was struck down by Honorable Calcutta High Court on the ground that this is a delegated legislation, and the delegated legislation cannot be retrospective. And while giving the judgment, though it was on the NCLT circular, they also said that even NCLET or IBBI doesn't have power to notify any regulation which will have retrospective effect. So those limited interpretations are there, but as far as the wires of the code provisions are concerned, Supreme Court generally directs that it should be before the Supreme Court, not the High Courts.
Okay, thanks.
Sir, there is one point which is with regard to the regulation with regard to SEC constitution.
Yes.
Still, It has not been notified in the act, but it has been come through a regulation. How do we handle that?
Which one you are referring to?
The constitution of the SEC, based on the principles of COC.
That is for the liquidation.
That's for the liquidation.
Yes.
No.
We'll have to abide by it.
But it is by a regulation. It is not mentioned in the act.
See, like that, there are many things. Even you use the concept of insolvency IP entity. Do you have any provision related to IP entity in the code, or any discussion on that about in the BLRC report? Any mention in the rules? No. It is a creation of the regulations, and it is assuming more and more importance.
Then does regulation overrule the code?
It is happening. So unless somebody, the courts will not take cognizance of it suo motu, unless somebody agitates the issue before the appropriate adjudicating authority or the appropriate competent court, the issues will not be decided. Okay, I'll give you an interesting example of Cricket Control Board of India.
Yeah.
From the name, it looks like it's a institution owned or controlled by the government body. So till the dispute related to this presidents and all happened, and the matter was before Honorable Supreme Court, that time it was discovered that it's a private society which has slowly taken control of the sport activity of the cricket, and it has become very rich by taking all the rights of broadcasting and all those kind of things. So unless things come to challenge at the appropriate level, you will not know, and this is how the things grow over a period of time. Like the IP entity has now become eligible to perform the activities as an insolvency professional. Some of the friends may not like my comments, but that's a fact. Any other issues? Okay. Generally, I give the example of two cases when we say what is the stringency of the requirements from an insolvency professional and otherwise. This is P. Narasimha Rao's case, no confidence motion, where some of the MPs took part in the voting process. Some of them abstained, and the consideration was bribe. So because of the law, immunity provided at the floor of Parliament, the MPs who took money and voted in favor of the government were exonerated. But the MPs who took money and abstained from voting because they were not at the floor of the Parliament, they face the criminal penalties. But in case of a professional member, the laws are so stringent. This is an example of a chartered accountant punished for some of the irregularities. A member of the institute, whether in the practice or not, shall be deemed to be guilty of other misconduct if he does something which brings disrepute to the profession. So similarly, clause 2 of the Code of Conduct of the Insolvency Professional is worded in the same manner, and that opens up wide responsibility for the insolvency professional when he is acting, even otherwise as an IP, he is liable for action if the profession is disreputed. So that is the difference between the law for a politician and for a professional, and we have to live with it. So our standards of ethics, integrity, and transparency has to be much higher than the normal in the society. This we can skip on. Now, as far as the code of conduct for insolvency professionals and even the regulations related to IPs has evolved over a period of time, and instead of bringing clarity, it has brought more of confusion among the regulated ones and the regulators. Because everybody will put something which he or she thinks appropriate without considering the overall impact of that particular change. So over a period of time, there have been changes in the regulations, like Regulation 7B, BB, CA, CB, 7A were added, 10, 12, and Code of Conduct also seen a lot of changes based on the outcome of the disciplinary proceedings, based on the inspections and investigations carried out by IPAs and IBBI. Wherever they found any fault in the system, they tried to plug it with an additional provision in the Code of Conduct. So now our Code of Conduct as IP is much more comprehensive and stringent as compared to other professions. Okay. Instead of going through all the provisions of the Code of Conduct, we'll just see the new ones. 3A was added. An IP must disclose the details of any conflict of interest to the stakeholders whenever he comes across such conflict of interest during an assignment. So there is a responsibility to declare relationship within 3 days of the event happening. And there is a responsibility which is continuing, like if that relationship occurs later on, then it has to be brought to the notice of IPA. The next one is 8A. An IP shall disclose as to whether he was an employee of or has been in the panel of any financial creditor or the corporate debtor to the COC and to the IP agency of which he is a professional member, and the agency shall publish such disclosure on its website. So here it is not a restriction, it is a disclosure. And the background of it is that in some of the cases, the banks have appointed IPs who were empaneled with them as IPs or for other activities. And this was challenged. I am forgetting the name of that case. It was one of the party was SBI. So adjudicating authority held that since the IP who is named to replace the existing RP is a pensioner of the bank, he is not an independent person. NCLET also upheld the judgment of NCLT. The matter was then before the Honorable Supreme Court. So by the time it was with Supreme Court, wiser counsel prevailed over SBI, and they suggested another person to be appointed as RP. So this issue was not decided by Honorable Supreme Court, that whether a person who is in a pension is ineligible to become an insolvency professional. But the issue was partly decided in the sense that the Supreme Court has held a person who is getting a pension is not an employee. He may be an employee as per the Income Tax Act for the taxability of his perquisites as pension, but that doesn't lead to any situation of employer-employee relationship. So that's why this regulation then came into existence to bring in transparency in terms of disclosure, whether an insolvency professional has been at any point of time related to a financial creditor in any other capacity. So these are all the outcomes of developments of judicial pronouncements or disciplinary activities or inspections or investigations carried out. Similarly, clause
Sir, this
8A
8A is still
CD,
there and has not been finally concluded
disclosure
by
of
the Supreme Court, right?
relationship are added. That issue has been settled by the Supreme Court, and the Supreme Court has decided that a person who is getting pension is not an employee. But since the name of RP was withdrawn, they have not decided whether such pensioner is eligible or he is an independent person to be appointed as RP or not. Is that clear?
This provision does not only about employee, has been in the panel of any financial creditor. See, many of the ex-employees are in the panel of bankers.
Yeah, so here it is only a disclosure, no restriction.
Okay, it doesn't operate as a restriction.
You see, the language is very clear. An IP shall disclose as to whether it is to bring in transparency in the whole process.
Right.
Whether he was an employee or has been in the panel of any financial creditor or the corporate debtor, to the COC and to the IP agency of which he is a professional member. And the agency shall publish such disclosure on its website. So that is all available on the website. Similarly, 8B, disclosure of relationship, are not restrictions. They are disclosures. Even if somebody has a relationship indicated in these clauses, he is not restrained to become an insolvency professional or appointed as RP. But it is just for transparency and disclosure to the public at large. Earlier, this was by way of a circular, which has now been imbibed in the, or which has been embodied in the Code of Conduct. This was earlier by way of a circular way back in 2018, which is now converted into clause 8B, C, and D of the disclosure of relationship. Now, these are the kind of relationship which has to be disclosed within 3 days of that event. And the disclosure has to be to the IP agency of which the IP is an enrolled member. So one set of relationship with these stakeholders, relationship of the insolvency professional. Similarly, the relationship of other professionals appointed by the IP has also to be disclosed within 3 days. And there is a similarity, like all these stakeholders, if there is any relationship with the IP, all these stakeholders, if there is a relationship with any of the professional appointed by the RP, like auditor or a transaction review auditor or a professional of a specific field or the valuers or any other professional which has been appointed by the IP. Now, these are the kind of relationships. So these relationships are permitted. Even if the relationship falls into any of these 4 categories, there is no restraint. The person can still be appointed. But the only thing is that relationship has to be disclosed on the website of the IPA concerned. So this is different as compared to regulation 3A of CRP regulations, where there is a clear no. If anybody is fitting into those criteria of independence, not fitting into the criteria of independence, then the person cannot be appointed as IP. But here, these criteria of relationship are only for disclosure to bring in better transparency, not for any restriction.
Sir, I have a question here.
Yes,
I
please.
think under code of conduct, somewhere it is mentioned that, the professionals, if they are related to the IP, they cannot be appointed. Somewhere the code of conduct, it is mentioned.
That is there. We'll come to that. That's another provision.
I have a simple question. If the person is a member of IPE, okay, and if IP, he cannot miss other professional of IP, whether he can appoint or not as a insolvency professional register vendor. That
we will come to that also specifically. There is a clause regarding that.
Thank you, sir. Thank you.
Now 8D, an IP shall ensure timely and correct disclosures by him and other professionals appointed by him, and shall provide a confirmation to the IPA of which he is a professional member, to the effect that the appointment, if any, of every other professional has been made at arm's length relationship. So this is a responsibility on the RP. He has to make that disclosure even for the professionals appointed by him. So what has happened initially, when there was a system of appointment of IPs through a bid invited by IBBI, because in section 9 application, the name of IP is not necessary to be given, and such cases when admitted, NCLT was asking IBBI to suggest a name. IBBI was inviting bids. And one of the criteria, the only criteria in that time was fee. So people started cutthroat competition. They started taking assignment at a very low fee. And after appointment, then they started appointing their friends and acquaintances in different positions at a very high fee. So in some of the DC cases, it was brought, and then there was a regulation brought in regarding that also, that you can't do it arbitrarily. It has to be at arm's length. (15A), this is new and also take care of it. Actually, it is not new. It was, I think, one of the second circular issued by the IBBI way back in 2017. But the scope has been increased with this regulation. It says, an IP shall prominently state in all his communications to a stakeholder his name, address, email, registration number, and validity of authorization for assignment, if any, issued by the IPA of which he is a member. So your address line, whenever you are sending email, please make it sure that all these contents are there in that. I have seen communication from many IPs as IRP or RP. They will simply say name and IRP or RP of a corporate debtor, nothing else. So it is, and there have been cases where the IPs have been penalized for not complying with this requirement. So your address line should be complete. It should include your capacity, whether you are as IRP, RP, liquidator, or bankruptcy trustee or whatever, plus your address which is registered with IPA and IBBI, your email, your communication details like telephone number and address, and your AFA validity. AFA provision was added later on, so this has been added in this. Another thing is regarding the number of assignments. So way back, I think it was in 2018, NCLT Hyderabad in Lanco case has held that the IP should not have too many assignments, particularly large ticket size assignments. But there was no regulation added. This was later in 2021 that this clarification was added to the Code of Conduct clause. An IP may at any point of time not have more than 10 assignments as RP in the CRP process, of which not more than 3 shall have admitted claims exceeding 1,000 crores. So again, this limitation is for what? From the language of this proviso, what does it indicate? The 10 assignments in what capacity? Does it include the position of a liquidator or a voluntary liquidator?
Yes, it should include all.
No, it should, but with the language, does it include?
No, obviously not.
What
Hello?
it says as RP in the
அந்த
CRP.
கிண்ணத்துல வச்சிருந்தியா அது என்ன சாப்பாடு?
It says only RP.
It says
பிரியாணி மாதிரி
only
இருந்தது.
RP.
Yes.
Anybody else
Okay,
is
fine,
making
right.
a point or talking on the phone?
Participants are requested to keep mute.
Now the question is whether the assignment as IRP is to be considered in this limit of 10 assignments or not.
IRP, yes.
IRP, yes. Why, Mr. Matthew?
Because even somewhere otherwise defined, IP includes IRP.
Yes, because in the definition of RP,
yeah, it is there.
It is clearly mentioned that it will include an IRP. Another question.
Yes, sir.
Whether an RP under a PPIRP pre-pack will be included here or not.
Yes.
Logically, yes.
Logically, yes, sir.
Yes, sir.
That
Yes,
is a CRP and he is termed as RP. So the understanding which develops from this is that the limit of 10 assignments will cover any assignment as IRP or RP or the PPIRP even, but it will not include for liquidation, compulsory or voluntary. And the subset says that not more than 3 shall have admitted claims exceeding rupees 1,000 crore.
Sir, even it will not include that authorized representative in case of real estate issues.
With the language, no. Because AR is only a very responsibility of more of communication.
Exactly.
Assume the responsibilities or authorities or liabilities of an RP. He's just a via media. It is like aggregator. He aggregates the votes of large number of members and represents them in the COC. So I hope that is clear.
Yes, sir.
This is the reason. Section 527 has been amended. It says resolution professional for the purpose of this part means an insolvency professional appointed to conduct the corporate insolvency resolution process or the pre-packaged insolvency resolution process as the case may be, and includes an interim resolution professional. So by virtue of this definition, the things become clear about this clarification or proviso added to clause 22 of the Code of Conduct. This is very important. Somebody would like to read this clause 23 and 23A.
An IP must not engage any employment when he holds a valid authorization for assignment or when he is undertaking assignment. 23A, where an IP has conducted a CRP process and he and his relatives shall not accept any employment other than an employment secured through open competitive requirement with or render professional services other than services under the code to a creditor having more than 10% voting power, the successful resolution applicant, the CD or any other related parties until a period of 1 year has elapsed from the date of cessation of such process.
So this is again increasing the ambit of restrictions on the insolvency professionals to take on assignments. Now there has been a DC case wherein IBBI has held that the RP who has taken the position as a member of the monitoring agency has contravened the provisions of clause 23A of the Code of Conduct.
Can you repeat it?
RP, after the approval of the resolution plan, was appointed as a member of the monitoring agency to supervise the implementation of the monitoring resolution plan. IBBI in a DC order has held that this is contravention of the provision because 1 year cooling period is required before he takes up any assignment.
But it is duty on the RP to monitor the implementation. It is there in the code as well. And I think in 90% cases, IPs and RPs are doing that.
Madam, that is not the duty of the RP to become a part of the monitoring agency. What is monitoring agency? Who appoints the monitoring agency?
CUC has CUC, SRA, they collectively their points because it is duty of the RP as well to check whether implementation is done as per the plan or not. So if he is not getting remunerated, then why would RP monitor the project for another 4 or 5 years, without getting remunerated for that?
That's right. That has been in fact the practice earlier.
Bolo Janam.
It
Bolo
was.
Janam.
Please mute yourself, those who are talking on the phone. Earlier, it was a practice that since the RP has been privy to the whole process of CIRP.
Hello.
May I request the person who is talking on the phone to mute?
Sir, I'll mute. I'll mute. Just a second.
Okay.
You see, earlier there was a practice, that there was a tendency rather, and it was an unwritten law. There's now no provision of monitoring agency in the code, regulations, or anywhere. It is part of that supervision and monitoring process, which is a compulsory element of the resolution plan. Section 30, subsection 2, and regulation 38, I think. So what was the practice? That RP was appointed as member or even the chairperson of the monitoring agency by the committee of creditors, because he was privy to the whole process, he knew it, so it was thought that he will be in a better position to monitor the implementation. And another set of representative was from the successful resolution applicant. Like the corporate debtor is not handed over to the SRA immediately on approval of the resolution plan. It is only after all the covenants or all the conditions or all the promises in the resolution plan have been implemented. That is payment to the creditors, operational creditors and all. And as per the terms that when the control will be handed over to the corporate debtor. So during the transition period, the monitoring agency will take control of the corporate debtor. RP is relinquished. But this recent interpretation, anyway, this clause 23A was added later on. And recently when IBBI interpreted it as that he has violated the provisions. The defense given by the RP was the monitoring agency is appointed by the adjudicating authority. It is suggested or initial appointment is done by the COC and the SRA agrees for it. And finally, the seal of adjudicating authority is put on it for appointment as member of the monitoring agency.
Sir, when 23A came in, put into force?
It is 23rd July 2019.
Okay, so even during 2019 period, it was a normal style that IP continued to be a member of it.
Yes.
So it means that being a member of this is deemed as an employment. Is it a correct interpretation?
Someone of you can check 23A because I think 23/7/2019 is for this explanation.
Okay.
So probably it is the same time. But this has again been challenged in the High Court. And the High Court has stayed the application of this DC order. because High Court has also considered the facts brought before it by the appellant, saying that this was suggested by the Committee of Creditors. It was approved by the adjudicating authority. So it is binding on all by virtue of section 31 of the code. The IBC contention here was that it was the duty of the RP. RP should have brought in his due diligence report that this type of arrangement will contravene clause 23A of the Code of Conduct, which RP has not brought in. And that's why it was part of the resolution plan, which was approved by the COC and then approved by the adjudicating authority.
So being member of an MA is deemed as an employment. It is a very narrow interpretation by the IBBI.
No, actually, this clause says employment and any other professional service. So it's not only employment, it says other than the employment secured through open competitive equipment with or under professional service. But it also says other than services under the code. So this service is especially provided in the act that RP has to supervise, the implementation supervision. And in real estate companies, the supervision would require for around 4 or 5 years until the project is completed. So if the IB is expecting RP to, keep on working for another 5 years and to supervise the implementation, I think it's somewhere, I don't know how it's interpreted.
So again,
and moreover, if you see further, it says services to the creditor having 10% voting power, SRA, CD, or related parties. In this case, this services neither is not to any CD, is not to SRA. Actually, it is only a duty to supervise the project. We're not giving services to anybody. If we see.
No, that's true. And that's why we wait for the High Court judgment, and maybe then it is challenging the Supreme Court, because by reading this clause, it's very clear that the RP taking the role in monitoring agency is not covered by a regulation, this clause 23A, because first thing, he is providing services under the code. This is by virtue of section 30, subsection 2, which talks about there has to be a mechanism for supervision and implementation of the resolution plan. The second thing is to a creditor having more than 10% voting power. So here the appointment is not by a single creditor.
Absolutely.
The appointment is by a collective body of the Committee of Creditors, which has the commercial wisdom of even to approve the resolution plan. So something there, somewhere there have been some gap in interpretation of it. Only time will
more importantly,
or bring clarity about it. But that
so
is
more importantly, 23A says other than services under the code. So service under the code is well covered. There is no restriction.
It's a debatable issue. I think there is no.
So that's why I
have a solution here.
all the words.
Let the court come up with the
Yeah, so the court will decide, and then we see our thing is very clear. For us, if IBPI has decided a matter, we'll have to go by it. And if it has been then
even if it is clear violation of the code,
we are bound by it.
Sir, from where can we get this order of the IBBI? If this was for in a particular case while conducting the proceedings.
This was in the particular case. This was challenged before the High Court of Delhi. Delhi High Court has put a stay on it, operation of it.
Is it available for other IPs as well? Because IBBI never, issued any circular to the IPs, regarding this.
These are available on the IBBI website itself. If you go to the IBBI website, then there are this one link for the orders of Supreme Court, High Court, NCLAT and NCLT. These are available on that.
Okay. So by IBBI's own orders are also there.
Yeah, IBBI's order, of course, are there. And this is in case of Mahendra Khandelwal, if you can search.
Okay. So do we have the date or month year, if possible, so that easy to...
I'll share.
Thank you.
I don't remember it right now, but maybe it comes from there.
So there was one case in which the RP continued putting the name signature as resolution professional even after the adoption of the resolution plan by the adjudicating authority. If that case relates to this, I think so.
No, it is not. That is a different case.
Okay.
This is clearly of acting as a member of the monitoring agency. Okay, who would like to read this slide?
Which one, sir?
This current slide, 23B.
I will read it also.
Yes, please.
An IP shall not engage or appoint any of his relatives or related parties for or in connection with any work relating to any of his assignment. An IP shall not provide any service for or in connection with the assignment which is being undertaken by any of his relatives or related parties. For the purpose of clause 23A and 23C, related party shall have the same meaning as assigned to it in clause 24A of section 5, but does not include an IP entity of which IP is a partner or director, with effect from 23/7/2019.
So this answers two of your queries. One query was whether any relative of an IP can be engaged. So there is a clear no by virtue of 23B. IP shall not engage or appoint any of his relatives or related parties for or in connection with any work relating to any of his assignments. So this is something different, as we have seen in clause 8B, C, D, the relationship disclosure. There was no restriction, but here there is a clear no. If somebody falls into this definition of relationship, he or she cannot be appointed in this process. Now come to 23C. The IP entity will definitely become a related party if we see the definition of section 524A. Initially, the role of IP entity was to provide services only to its members or directors. Later on, that was changed, that the IP entities can provide services to other IPs also. And at that time, this change was done because by virtue of the definition of relatives under section 524A, the IP entity will not be eligible to be appointed by an insolvency professional who is acting either as IRP or RP. That's why the specific exclusion was done. And this exclusion entitles the IP entities to be appointed in the CRP process where their member or a director is acting as RP. So I hope that is clear, both your queries. Or any queries with reference to this? Please confirm yes or no.
Yes, sir.
For me, it's an yes.
Yeah, okay.
25A, an IP shall disclose the fee payable to him, the fee payable to the IP entity, and the fee payable to the professionals engaged by him to either IP agency of which he is a professional member, and the agency shall publish such disclosure on its website. So this amendment has been done with effect from. This was initially done with effect from 1st April 2018. I am mistaken here. That was by way of a circular. The separate forms were to be filed, but this has been added as a clause later. Now this is part of the code of conduct. 25B, an IP shall raise bills or invoices in his name towards his fees, and such fees shall be paid to him through banking channel. Initially, when that circular of 2018 was issued, when the assignment was taken by the IP who was a member of large big four companies, the billing was done in the name of the IP entity. So in the disciplinary cases by IBBI, penalty has been imposed on such insolvency professionals because it was contravention to the circular. And now it is part of the code of conduct. So the IPs should be very careful. They should raise the bill in their own name, not in the name of IP entity. Of course, now IP entities are allowed to become IPs, so they can raise the name in their name if they are the IP. An IP ensures that IPE or the professional engaged by him raises bills or invoices in their own name towards their fee, and such fee shall be paid to them through banking channel. This is to discourage the practices prevalent, like where people take the invoices and they transfer the money to a different account. The prevalent all practices regarding share in the appointment fee. So one should be careful that the payment is to be made to the specific professional's bank account, and that professional has to raise an invoice for it. An IP shall not accept, share any fee or charges from any professional and or support service provider who are appointed under the process. So this type of practices are there rampant in any profession. They would like to have a share cut of getting appointed. So this is clearly prohibited. And this is a big challenge for the insolvency professional to take up assignments. There will be many offers for such type of considerations. So one has to be very, very careful. Okay, may I request someone to voluntarily read this slide also?
Yeah, I will like to read it. 27A, an IP shall, while undertaking assignment or conducting processes, exercise reasonable care and diligence and take all necessary steps to ensure that the corporate person complies with the applicable laws. 27B, an IP shall not include any amount towards any loss, including penalty, if any, in the insolvency resolution process cost or liquidation cost incurred on account of non-compliance of any provision of the laws applicable on the corporate person while conducting the insolvency resolution process, fast-track insolvency resolution process, liquidation process, or voluntary liquidation process under the code.
So earlier, for this, now it has been included in the code of conduct. And it has a very wide ramification. It's a very widely worded provision that it will take all necessary steps to ensure that the corporate person complies with the applicable laws. And this is comparable to section 17. We have seen in the prime duties that whatever laws are applicable to the corporate debtor, it has to be the endeavor of the RP to do it. Now let us consider an example. Before coming into the CIRP net, the corporate debtor was a listed entity. The company doesn't have funds. The listing fee is not paid. He is supposed to make the compliance. He is supposed to pay the fees. So what is the option available with the RP? What should the RP do? Should he get into non-compliance, or should he pay from his own pocket? Should he take the loan and pay that? Should he arrange interim finance and pay it?
So it depends on the quantum of the funds involved. Minor amount, he may pay from his pocket and get it ratified from the COC. And major amount, then he should first put it for the COC.
So do others agree that the RP should pay from his pocket?
Sir, it's
Legally not.
No, I don't agree.
He should ensure the payment, not from his own pocket, from other resources.
He should not pay from his own paper.
See, as far as the other responsibility of compliance with the law, like publication of the notice, or that in the initial period he is supposed to do even if he has not got the fund. But a legal compliance like that, he can't do from his own pocket. So what he has to do? He has to approach the COC. He has to make efforts for interim finance. And if he doesn't get success in that, that non-compliance will continue. So that has to be clearly understood. He has to make his best efforts to comply with the law. But that doesn't mean that he should sell his house and do all the legal compliance and pay all the dues. He is ultimately a professional. But he has to be very careful in bringing it to the notice at the earliest to the COC and try to get a resolution and record it properly and make all sincere efforts. Second thing is that if there is any penalty for this non-compliance, it will be a tricky question. Where in such cases, there is a penalty imposed, again, he can't pay it personally. So that will depend again on the facts and circumstances of a particular case. But wherever there is a non-compliance because of his negligence, then the IP is responsible. There was a circular earlier which said that all such penalties will not be part of the CIRP process cost. It will be the personal cost of the IP.
Is it anywhere mentioned that if it is only because of negligence, then only it will not be part of the cost, and if it is, it is not within the control, then I don't think it is mentioned that negligence word is not used anywhere.
There in the circular, but otherwise it has to be proved from the facts of a particular case. Like the one situation we discussed. If the corporate data doesn't have money and listing fees are generally very high, and if the exchange imposes a penalty, it'll be unfair on the part of the IP to bear such costs.
In many cases, we don't get the income tax login IDs and also returns could not be filed. There are many other such non-compliance that happen in the CIRP because of the non-cooperation from the corporate data.
No, that should not happen. Like filing a report, because MCA has authorized the RP to use his digital signature for filing the reports to ROC. Even the liquidator or the RP can use his digital signature to file the.
But in income tax, getting the retrieval of the username password, audit is not there. Nobody's auditing the accounts. You can't do the audit. You can't file the return. There are many non-compliant in many cases. You can't hold the AGM. Shareholders are not available. So there are many non-compliant that are happening because the companies are not active dormant.
Okay, wherever you are able to justify the circumstances leading to that non-compliance, I think you are exonerated. But if you are not taken any steps, like there is a provision in section 17, I think it is section 17, subsection 2D, that you have authority to access records available with the statutory agencies. So you have to make efforts. And if after the efforts you are not successful, then it's okay. But otherwise, you can't just take an alibi that I don't have these things, so I can't do it.
Sir, if IP, RP or IRP has not been provided, the financial statements up to the date of CIRP, how can he proceed further for preparing the financials and filing with ROC and income tax and complete the audit?
He can file an application under section 19, subsection 2.
That he has already done. Still, he is not doing. Then he is handicapped.
Then he has done his part. But there are
fine.
certain situations where the RP doesn't file the application and doesn't do anything, any process further.
Thank you.
You'll have to see what you are required to do, what steps sincerely you took.
Okay. 92 has already been filed and regularly following with the CDX management also for giving the financials up to the CRP date.
Plus,
but they have not given.
Using the provisions of section 17, you can approach the statutory authorities, statutory agencies to provide whatever details they have. And that provision is very wide. It is not only the information submitted by the corporate data earlier, but even otherwise, if such agencies have those information at their own, you have a right to access. It is like the income tax officer can ask you the information. Similarly, you can ask the the income tax department also, that please provide us whatever details in the form of returns or documents filed, or even otherwise you have about the corporate data.
No. That RP has obtained. Previous year financial statements have been obtained, bank statements have been obtained, but he cannot complete the financial for the after the CRP period because up to CRP date financials are not audited, financials are not there.
No, whatever information you have, you can compile it for the information memorandum.
Information memorandum has been compiled. That process is going on. But filing of financial statements with ROC and income tax audited financial, that is pending because of that.
So that you can't help it. Certain situations are there. But what you should do is you should endeavor to show that you have made all your efforts.
Yes, status report has been regularly filed with NCLT and following up with CD for providing that information.
When we talk to the senior officials of IBBI, they clearly mention that the penalty is imposed only when the actions are nullified. If there are bona fide actions and genuine mistakes by the IPs, they don't put severe penalties on that. You will see in many disciplinary case orders, they say just the RP to be more careful.
Sir, when it is beyond the RP, well, we can't fulfill the requirement and the non-compliance, then where to go? Just go to the knowledge of the NCLT or where?
See, the only
we are taking all the efforts, we are talking to the external agencies, income tax, but still we are not able to get the information. So where to go? Either to only to mention the application with the NCLT or any other way.
Your single point contact educating authority and keep
NCLT 19 to 1
reporting to the IBBI.
आशु जो सुन लिया मैंने there.
दीपक जी अच्छा लगा आपकी आवाज सुन के मुझे भी. Sir, IBBI को intimate करना है ये सब. We are doing that now, filing CRP forms and other.
Section 208. Section 2, clause D. You have to update IBBI as well as the Insolvency Professional Agency about all the proceedings. So what you do generally is you are submitting a status report or a progress report to the adjudicating authority periodically. So a copy of the same should be sent by email to IBBI as well as IPA. And then there are this CRP forms 1 to 8, stage-wise, stage-related progress that you have to keep on filing. So that's it as far as the code of conduct is concerned. We will have a break of 10 minutes and thereafter we'll continue with the disciplinary cases. So we meet at 12:30 again.
Sure, sir. Yes. Thank you.
Yes, sir.
Yeah.
Thank you. So welcome back. Can we start again?
Yes.
These are few small cases I want to bring to your attention. You had asked about this IBBI case regarding monitoring agency. This is Mahendra Khandelwal case and High Court of Delhi. This is the citation. So this issue was discussed. Clause 23A. And definition of section 523. So High Court stayed the order passed by the Insolvency and Bankruptcy Board of India. The defense was that petitioner came to be appointed as member of the monitoring committee pursuant to the directions of NCLT itself. We'll just discuss two small cases. Relationship inter-se the insolvency professionals. In this case, the liquidator died during COVID period. Another liquidator was appointed and he did not pay the fees of the previous liquidator because he was RP also. And then he filed an application for getting the records from the son of the deceased liquidator. So here the Honorable Enclet held that there is no personal liability of the son of the deceased liquidator to supply documents as was claimed by the liquidator, which could not be located in the papers. Furthermore, whatever the documents were there with the son of the deceased liquidator has already been submitted. So in this case, it was a very bitter fight among the insolvency professional and the legal heir of the insolvency professional. So one should be very careful about what is the right, to what extent one should insist for these things. The second was again between two RPs. Erstwhile RP claimed that the original resolution plan was burnt. New RP sought approval to place before the COC duplicate copy of the resolution plan. So adjudicating authority permitted subject to the willingness of the COC to consider it. Now you can see the height of negligence that the original resolution plan is burnt. And that's why the IBBI becomes very strict with everyone, and they impose a lot of restrictions or bring in the regulations which are more stringent. So inter-C, we always complain about the difficulties faced by the IPs, but there are many cases where the IPs among themselves do not behave properly and they litigate. Now we'll start sharing the specific DC cases. So I'll start with the latest first in that reverse order. Just a minute. This is the case of Mr. Sanjay Singh. He claimed fees for verification of the claims. I'm sharing the order of IBBI. So this was Mr. Sanjay Singh, RP of JSM Devcons Private Limited. So the issue against him was that he was charging fee for verification of claims. 500 rupees per claim. And that was, he thought, is in addition to his fees. So IBBI ordered for refund of this fee to the corporate debtor. In defense, the IP brought out that since in the form of cost of expenses, all these details are to be written separately, and that's why he has done it, because there is a cost involved in verification of the cases. There was another similar case of outsourcing duties, where the RP outsourced the responsibility of claim verification. So that was also held as contravening the provisions of Code of Conduct, because it is the primary responsibility of the RP to verify the claims. He can take assistance of his staff, or if the volume of the claims is very large, he can take the support of professionals, but he can't totally outsource the responsibility to somebody else. Another submission was that because verification, what justification he gave was the cost incurred are in the nature of office expenses. It is not imperative on the IRP RP to incur office expenses of several types out of his professional fee charged by him. So that was the defense he gave for charging a separate fee of rupees 500 per claim for the various claims. And this was also approved by the COC. So that brings to another issue, that if there is anything contravening the provisions of the code or regulations or code of conduct, even if it is approved by the COC, it will not be legalized. So in this case, maybe depending on whatever explanation the RP gave to the COC, COC approved it, and but IBBI found him guilty of contravening the provisions of Code of Conduct. Second default was that the report certifying constitution of the COC was delayed. So it starts from the issue of claims. The claim verification were delayed. The report certifying constitution of the COC was delayed. And again, the holding of first meeting of the COC was delayed. one of the defense given, this was a home buyer's case. So he gave that most of the payments was received in cash, and he didn't have any record to verify the claims. So and another reason pointed out was that due to delay in communication of the order, the notice of the first meeting of the COC was issued on 13/5/2022. Now here the issue of appointment of authorized representative is involved. What the RP has to do, if the case involves class of creditors having more than 10 members, then he has to give the name of 3 IPs to represent each class of creditors. The application is filed before the adjudicating authority, and the adjudicating authority has to approve. Now, what happens if a COC committee, COC meeting is held before approval of the names by the adjudicating authority? Can he do it? Can he not? Like there are 2 provisions. One says that within so many days of constitution of COC, you should hold the COC meeting. There is another provision which says that the ARs will be appointed by the adjudicating authority. So if the adjudicating authority has not approved the names, what the RP should do?
In the meeting, as per the guidelines.
Who will attend the meeting?
The COC members who are other than the home buyers, or you can make a observers of the home buyers, a committee of small people, where they can attend on behalf of the home buyers.
Is it as per the law that he can make a committee?
See, sir, actually, how do we act according to the situation? It's a situation, right? It is not that you are doing it deliberately to do something wrong.
Yes.
You are trying to convene a meeting, which is to be done within 30 days from the date of whatever the period is.
Yes. So
that should be the process.
More appropriate action in this case, if there are creditors other than real estate allottees, to have a meeting convened, and then either you can adjourn that meeting.
Yes, we can adjourn the meeting, and you can even,
or you can say that the next meeting will be held after appointment.
Appointment of the adjudicator, the observers, what to say, the authorized representative by the IOA. Yeah.
Or can mention with the adjudicating authority to take up the application early. So again, the essence is that he should show that he tried to comply with the provisions. He made all his efforts and he couldn't do it. So that prima facie action on the part of RP is required.
So my humble submission is, whatever the best possible, you are working as an officer, right? What best you will do to try to solve the situation should be acted upon. You should never take a surmise that I don't have this, so I cannot do this. That's not your prerogative. You should try to do something that is what is legit, or whatever is according to the rules of the game. You have to do your duty. Simple. Come what may. Come what may. Come what may. We are supposed to, sir, unnecessarily, for example, you are filing an application, the CD files an application against you that the RP is not performing its duties. And adjudicating authority does not take the application on its face value. It just says, file your reply. You have to do it. It's as simple as that.
True. So here in this case, the order was the RP to be extremely careful and diligent in performance of his duties under the code, and also directs him to deposit an amount of Rs 1,87,000 in account of the CD. This was the fee they charged. So here it was a very mild penalty. In fact, there's no penalty. He has been asked to repay the money which he has taken for verification of the claims.
That amount deposited by IRP will be part of CRP cost, 1,87,000.
No, since it is deposited back to the corporate debtor, it doesn't remain a cost.
Okay.
It is, if it was not refunded, it would have been the CRP cost.
Okay.
The next case is of Mr. Pramod Kumar Sharma. This is regarding appointment of a third valuer on the insistence of the committee of creditors. Now the provision regarding appointment of valuers says what? Two valuers will be appointed. And if there is a substantial difference in the valuation of the two valuers, the third valuer will be appointed by the RP. And what is the definition of substantial difference? What is the definition of substantial difference which will cause a third valuer to be appointed?
If the value is more than 20%.
20.
20, 10, 20, 10.
Yes,
Okay.
sir.
Earlier, there was no such provision quantifying as to what is substantial difference. So people were having a practice that if 10 or 15%, then they will appoint the third valuer. There was a judgment of Honorable Supreme Court in case of valuation related to this merger and acquisition, where they have said that more than 15 is substantial difference. But that was not applicable to this situation of IBC. Later on, the amendments were done in the regulation, which says that a difference of 25% or more will be considered as substantial. So if the valuation of the two valuers differ by 25% or more, then the RP is obliged to have the third valuer appointed. But again, it's the responsibility of RP, not of the COC. So in this case, what has happened? This was a COVID period situation. The valuation was done prior to COVID. The resolution plan was submitted to the COC with the due diligence report of the RP. COC wanted to have the valuation done just for its own knowledge before approving the resolution plan. So RP said, no, can't be done. He can't have the third valuer appointed. Again, COC insisted in another meeting to appoint a valuer. So it was made very clear that the valuer will be at the cost of the COC. There is no provision in the code for appointment of third valuer by RP. RP coordinated because RP was in control of the assets. So third valuation was done. The only mistake which RP did was in Form H, the valuation details are to be given. Isn't it? So RP gave the valuation of third valuer in form. But later on it was rectified. He filed a fresh Form H wherein the valuation of the first two valuers was included. So one has to be clear about all these provisions. In this case, the valuation by first two valuers was 126.3 crores and 121.1 crores. And the third valuer was, I think, somewhere around 56 or so, 52.69 crore. So the allegation was that the allocation of resolution amount was wrongly done based on third valuation, where the operational creditors suffered because there is a provision in section 30 subsection 2 clause B that the operational creditors have to be paid liquidation value payable to them under section 53(1). So the contention was that since the liquidation value has been drastically reduced in the third valuation, the operational creditors suffered. And that's how the NCLAT did the resolution plan back to the adjudicating authority to look only to that specific issue. They have not rejected or set aside the whole resolution plan, but only with the relation to the claims of employees. So in his defense, what the RP has pointed out that the final resolution plan was submitted by the SRA for consideration of the COC before the third valuation was done. And it was also submitted by RP to the COC. So that was his relief, that he has not actually acted on the third valuation as far as the resolution plan was concerned. His only mistake was that in Form H, he included the valuation amount as per the third valuer. So the same resolution plan, except only to the payment of employees, were marginally increased, was approved by the adjudicating authority. And here, the so-cause notice was disposed of by a warning to be more careful in representing the matters before adjudicating authority. No penalty was imposed, pecuniary.
Just a question. This comment came in spite of the fact that the RP had already amended the Form H?
Actually, the whole matter was remitted back by appellate authority because of an application filed against the resolution plan by the operational creditors. And probably realizing his mistake, when the resolution plan was under consideration of the adjudicating authority, he has submitted the revised Form H, indicating the valuation done by the first two valuers.
Okay.
There's another relevant case cited by NCLT and then by Honorable Supreme Court regarding the average of the valuation. When there are two valuers, if there is a substantial difference, you appoint the third valuer. What valuation average amount will you take for the purpose of resolution plan or your Form H?
Average valuation.
Average of which two? There are
Average
three.
of?
First two. Average of the first two.
Average of the
first two.
Then what was the need of taking third valuation?
No, if the third valuation is there, then the average of all the three.
No, average of the acceptable two, which you accepted.
And what is the definition?
Average of the above two.
Hmm?
Average of the above two.
Average
More
of
value.
Above means higher.
Higher values, yes.
Okay, and what is the provision in the regulations? The regulation says the average of the two nearest valuations. So going by that, in Maharashtra Seamless case, the RP took the average of the two valuations which were closer, and incidentally, those two valuations were less than the highest valuation. So Honorable NCLT passed an order saying that when the object of IBC is to maximize the value of assets of the corporate debtor, he should have taken the average of the two highest, not average of the two closest. So there is a clear contradiction in the regulations and the judgment by the NCLT. The matter went to Honorable Supreme Court, But that was on an issue that the resolution plan approved value was less than the liquidation value. The Supreme Court didn't make any comment on what average should be taken. But this was the case where the Supreme Court has held that the liquidation value is of no relevance when you are approving the resolution plan. It is the commercial wisdom of the Committee of Creditors to decide the resolution plan. And there is nowhere in this IBC written as to what should be the value of it. Nowhere it is written whether it should be equal to or more than the liquidation value. So this is another dimension of the commercial wisdom of the COC in approving a resolution plan. Is that clear?
Yes.
Yes, but there is, I'm getting repeatedly the sound of somebody clearing their throat. If people not talking can mute, you know.
Maybe it is mine.
It's not you, it is in the background. Okay.
So now we take the next case. The third one is of Mr. Rohit Vohra. This was a typical case of non-cooperation by the Committee of Creditors. And also confrontation, open confrontation between the insolvency professional and the COC member having a majority stake. Here, the COC decided to replace the resolution professional, but it did not file an application before the adjudicating authority for its approval. And in the period of uncertainty, the resolution professional continued to provide the services as per the law. Thereafter, because of this stalemate and confrontation between the RP and the COC, there was no resolution because Form G was not published. And the agenda for taking the company to liquidation was brought before the COC. Without the approval of the COC, the issue was the COC does not want to continue the RP as a liquidator. So they deferred the matter for replacing the RP before pressing the application for liquidation. In the meantime, RP filed the application for liquidation without the specific authority of the Committee of Creditors. And while arguing the application before Honorable NCLT, the RP opposed the application for liquidation, saying that the company is viable and it can be resolved through the resolution process mechanism. So adjudicating authority recorded all these things and passed a stricture against the insolvency professional that he is going against his role and responsibility and he is contradicting the issues. One allegation was that he had already started giving the control of the corporate debtor to the existing management. And he also didn't cooperate with the IBBI in the investigation process. He kept on avoiding giving the reply. That added insult to injury. And that's why there was a penalty of suspension of his license or registration. Another interesting difference between inspection and investigation, if any one of you is aware about it, and the IP wanted to bring that defense into picture for giving reply. He said the draft inspection report was not given to him, and as such, he was not able to make any comment on that. In IBBI regulations for inspection and investigation, there are provisions related to inspection report and investigation report. And the difference is, in case of inspection report, draft report has to be shared with the person concerned or the service provider concerned, and he has to give his comment. Based on that, the report will be finalized. But in case of investigation, there is no such provision. In case of investigation, the draft report is to be shared only with the IBBI. And IBBI will make comment on that. Accordingly, the report will be finalized. So he tried to take defense of that regulation. Though it was an investigation, he tried to use the provisions of inspection. Excessive fee claimed. His fee was rupees 3.75 lakh per month. Because of the stalemate and collusion with the committee of creditors, he was not able to run the whole process of corporate insolvency resolution. He said he has incurred an expense of around 1 crore 68 lakh. So that was considered as very substantial amount by the adjudicating authority, and strictures were passed against him. That was another reason for disciplinary action against him. And then he claimed the expenses of filing all such applications multiple times. So the bench has taken a very serious note about the conduct as well as the way of charging fee by the RP without doing any work. And this was the basis for investigation by IBBI and thereafter disciplinary committee against the insolvency profession. A very long order, so I'm just taking you through the key issues related. He also did not inform about the relationship disclosure, like the relationship disclosure was delayed by 555 days. In some cases, 58 days, like that. He also did not file the form related to the cost disclosure. The CRP forms were not filed with the board. So finally, the board took a decision to suspend, the disciplinary committee took a decision to suspend the registration of the Rohit Vora for 1 year. Now mark the line in para 8.4. The DC also takes note of non-cooperation on the part of the COC members.
Hello?
Religare Finvest Limited. Please mute your mic, those who are talking on the phone. You are disturbing the whole session. Several times. Surbi, please mute him. You're taking disadvantage of the virtual training. You get the CP hours, you disturb the others also. Now, just remember the discussion we had in the initial page. What is the authority of IBBI to impose? Is it Mr. Sivaraman?
Yes, it is Mr. Shivaraman's mic.
Yeah, he's not.
Yeah, he's not on his seat actually. He left his room.
Yeah, that's the advantage of virtual hearing, virtual training. You get the CP hours without attending it. So just note the wordings here. IBBI DC has found that the COC member was not cooperating. But what the action they could take? Nothing. They have just observed it. That DC also takes note of the non-cooperation on part of the COC member, the relegator of invest. Time-bound resolution is closely knit with the value maximization maxim of the code, and taking months in effectuating the replacement of RP has virtually derailed the whole process. The order may be brought to the notice of higher authorities of the bank for taking suitable action against erring official as they may deem fit.
So this is highly unjust, because when they find fault with the COC member, there is a heavy penalty imposed on the RP. This is really violation of natural justice.
This is unfortunate because, as we have seen, out of the 4 pillars, the most important pillar is IP, but it is the weakest pillar because it's a private professional, and the other 2 pillars are the government authorities, plus one is also a company incorporated by the public sector undertakings. So the only vulnerable position is that of the insolvency profession.
Sir, with due respect to IBBI, the IBBI and the IPA are supposed to enable the IP, who is the only working pillar.
That's true.
And reporting to everybody. Reporting to everybody. Be it IPA, IBBI, be it NCLT, be it COC.
Everyone is actually running point.
Unfortunately, the impressions have been created by our own fellow professionals because of their misdeeds. And as I told you in the beginning,
this is the beauty of
the
law, because everyone after the RP.
Yes.
Sir, IP is a punching bag.
And we all offer that back to the people because we have voluntarily come into this profession and somebody pushed us. Okay, now we take one more. We'll take
one thing, sir.
Yes,
we
please.
have come into this profession to do work. We have not come here to get brickbats. That's my humble opinion.
That is true.
Yes, I totally endorse. The grace should be maintained.
Sir,
we should be treated like that. And Sharma ji, I request there should be some forum. We are all discussing. We all know that somebody is saying we are punching back. So where we should wind out, there should be some place. IP is not listening. IBBI, what is the place where we can say all this?
There should be some forum that our issue should be raised to the authorities.
See, there are so many forums created. There are associations of the IPs, but you know very well what they do.
No, sir, we definitely require the code of conduct for COC also. We require the definitely code of conduct for COC also. But there are instances where COC is delayed.
Yes,
there are instances.
I really agree. There should be code of conduct for COC also.
See, there has been a very serious deliberation at the level of IBBI senior officials. They are also apprised of this problem. But I told you in the very beginning, there is a legal impediment. The IBBI does not have any authority over the banks. Though via media, one regulation has been added in the CRP regulations where they talk about the responsibility of the COC. But since there is no provision in the code, it is hardly enforceable. And we have to live with it till RBI or any other regulatory authority takes very proactive and stern actions against this defaulting COC members. Because they have been responsible for all this NPA situation, one of the party, and now they are in the decision-making seat.
Not only that, sir, I have, in my experience, the COC members attend the COC meeting. They agree for certain things. And they put certain things for voting. And for voting, they take a lot of time, 2 weeks, 3 weeks, months. Just to decide on the voting. And voting is done by some senior person.
Although there is IBBI circular is there, that whosoever is the decision making, only that should participate in the COC. Still, they are forcing RP to allow voting, and then they are not voting. That taking
Not
time.
agreed in that meeting. Yes, voting not as per the agreement in the meeting.
Is that what authority IBBI has over the banks? They have issued the circular. The responsibility of RP has increased, and that circular was issued long back. IBBI will also come out with a draft code of conduct for the COC. IBBI is trying. They are in talk with the IBA and other, but there is somehow no breakthrough in this issue. There are certain things I can't disclose at this forum, but the reason is the ecosystem in which we operate, there is lack of governance, and which is causing all these problems.
But breakthrough is always against the RP. When they are issuing this very circular against fixing the responsibility of RP, expect all aspects.
The weakest link will always bear the burden.
Sir, when you said lack of governance, I'm not getting it. What do you mean by that?
To be plain and blunt, corruption.
Okay. Right, I understood.
Every form and dimension of it.
Yes, sir, I can understand.
Sir, one small thing is, who will accept his own mistakes, sir?
Nobody.
Nobody. It's simple as that. It is simple as that.
See, forget about these institutions. Take our own case, me and you. If we make mistake, how many times we are honest to admit it?
Honest. That very few times we do it, but not at the most of the times. Because we need to save our skin. That's a major part of it.
That's why everybody is busy saving the skin, and in the whole process, the body of the economy is disturbed.
That is very true. I agree to it. Sir, there is only one thing which always comes to my mind is Mahabharata. Everybody is right in his own perspective. But the midway point is the only point where we can meet. That midway point is never met. That is where the issue is.
The issue is that we have taken individual interest to the core, and we have ignored the group interest.
Honest.
And that's why all this happens.
Honest opinion.
Okay, because this discussion will be endless and we'll lose the perspective of the purpose of this session. So I'll have last disciplinary case, which will expose the whole system. Okay, before that, I'll take the judgment of Anklet in that case. That's the background for the disciplinary case. The word file is visible?
Yes, sir.
Yes,
sir.
This is a classic case. Hindalco Industries versus Hirakud Industrial Works Limited. The long history is that it was part of the privatization movement where one of the government undertaking was sold to the private entities. And that time there were dues of the workers. So one of the covenant of that privatization agreement was that these worker dues will be paid. Unfortunately, the company got closed and those buyers got in collusion, sold it to somebody else, and then tried to use the IBC route for liquidation so that the huge amount of liability to the workers is avoided. Why I said classic case? Because this exposes the adjudicating authority also. Here, the application for CRP was made by the financial creditor of that corporator, who was a related party of the CD. The directors of the financial creditor and the corporator were common. And they somehow got the insolvency. This process started. The RP who was appointed knew everything. Still, he appointed the related parties as part of the COC, which he shouldn't have done by virtue of the provisions of the code. And the successful resolution applicant was also a related party, which would have breached the provisions of Section 29A. The management of the corporate debtor was handed over to one of the members of the promoter family before the resolution plan was approved. So all these sins were committed. Still, the CRP application was admitted. The resolution plan was also approved. It was only with the intervention the employees sought at the level of NCLET that the resolution plan approval was set aside. And you see the height of courage of such people, the nexus. There was a judgment of Honorable Supreme Court for payment of the dues of the workers. High Court of Odisha was supervising that payment process.
The payment for dues of
workers.
Okay.
And despite all these orders of the apex courts, the RP got in hand in glove with the promoters and got a resolution plan approved. So finally, this was set aside, and by the direction of the NCLET, investigation was taken up against the resolution professional. And this is that great person. So what was the directions of Honorable NCLET in this case? A penalty of 50 lakh rupees was imposed on each of the financial creditor, Nandakani, and the corporate debtor. Payment of 40 crores made by the successful RA was to be refunded. And this is a fit case to be investigated further by the Insolvency and Bankruptcy Board of India regarding any possible collusion between the RP on one hand and the corporate debtor. So IBBI will investigate the conduct of RP, Mr. Anandarao Korada. And it was because of the directions of the NCLET that this disciplinary action was taken up. So now you can see the footprints of deeply rooted malice of corruption in the whole system. So this is the long order. Is it visible, the PDF file?
Yes, it's visible.
So here, the registration is cancelled.
Okay.
For life. Because Mr. Korada was fully aware about the long pendency of the workmen dues and their continuous efforts for its payment before various forums. However, Mr. Korada had shown a casual and lackadaisical approach with regard to the workmen dues. And the whole thing was managed. The whole process of the CIRP and the resolution approval was managed. So with that, we will close our discussion on the disciplinary cases. We have 15 minutes for question, answer, or discussion, or any of your observations, or if you want to share any cases for the benefit of other participants.
Sir, in most cases of IBC, the employees normally get pittance or nothing.
See, that is because of the provision of Section 53. Section 53, the last priority is such unsecured creditors.
No, I'm not saying even workmen, which are defined in ID Act.
Workmen will get priority, their 2 years dues. Employees will get priority of 1 year dues. Rest all will be treated as the last category, other creditors.
Yeah, but even workmen, that's my general impression about what has happened.
Yes, the protection is only for 2 years. And beyond that, they are really not protected. In fact, it is very interesting. If you remember, the threshold for CRP initiation earlier was rupees 1 lakh. And what was the justification? The justification was that even at the slightest default, and even if non-payment of one worker's due, minimum wages was something around 8,000 rupees, the company can be taken into insolvency process. That was the
correct
behind IBC. But
the intention of the act was something different, when now it is something different.
Even the premises of IBC is for honest business failure. Whereas we see
exactly,
that
sir. Exactly.
90% business failure is because of fraudulent transactions or diversion of funds. If you see in terms of the quantum of PFU applications filed by IPs, that is around 2.5 lakh crore, which is only a tip of the iceberg. These are only the transactions which they could identify within the limit of look back period. Imagine how much money would have been drained over a period of time.
Sir, my question is regarding in case of acquisition of a company.
आशीष जी आप थोड़ा सा जोर से बोले, मुझे सुनाई नहीं दे रहा है.
Yes, sorry. Sir, my question is regarding a resolution plan for acquisition of a company where the ROC filings have not been done. The resolution plan clearly states that the resolution applicant requests for immunity from the penalty for updating the ROC filing. So I just want to know whether and the NCLT has approved the resolution plan without any remark on that. I just want to know, because ROC refuses to accept that. They said we'll not accept any filing without any penalty. And they say you are welcome to approach the NCLT and file contempt against us, and we'll file reply over there. I just want to know, is there any precedence where waiver has been made by ROC for any penalties, because they have 5 years of pendencies of filing of the returns and the balance sheets and all those ROC filings.
You see, that's the purpose of introduction of section 32A. 32A provides immunity to the new management.
Yes.
They can't be made responsible for any of the sins committed by the previous management.
Okay.
And this is also very clear that any non-compliance prior to the corporate insolvency process, the RP or the current management will not be responsible. The prosecution can continue against the persons who were responsible at that point of time. It is the adamant view of the ROC. They don't understand that why they are imposing or restrictions on the resolution plan approved. Section 31 provisions, if you say, the resolution plan approved by the adjudicating authority will have binding effect, and it will be binding on all stakeholders, including all governments, central government, state government, or local authority. Nobody can challenge the provisions of that.
So what is the remedy for us, sir?
Pardon?
What is the remedy? How do we do the filing? Can we do it through GNL to just do physical filing and then sit on it and wait for the ROC to take action?
ROC is not accepting that filing because of, are they not allowing the digital signature to be put in?
They said you do the physical filing, and when you go ahead for physical filing, you have to comes with the penalty. You can't file unless you pay the penalty or the delayed filing fee.
Because nowadays, whenever there is a problem on the site of ROC and you request for physical filing, they say, no, you have to file it online only. In your case, they are insisting that you come for physical filing. There are problems with ROC, even for filing of this final dissolution order using form INC 28. At times, you don't take it on
शर्मा
record.
जी, मेरा यहाँ पे एक व्यू है, आवाज आ रही?
Sir, हमारा one more issue. This is regarding
मेरा यहाँ पे व्यू है कि
since the balance sheets have not been signed and the income,
ICSI IPA go na capacity.
is there any immunity on that? Because there also we have, in our resolution plan included the clause saying that we will be, totally immune to any penalties for non-compliance of the income tax. So now we can't file the returns online because after 1 year, the department doesn't allow.
These are the practical issues. Actually, when the resolution applicant puts up a resolution plan, he asks everything under the sun. They will ask for all the exemptions. And you see what is the authority of NCLT. You'll see in many of the orders, they clearly say that for any relief or concession, you have to approach the relevant authority. They can't give all these exemptions and authority. The only issue is that in case of claims, whatever is submitted in the resolution plan, that becomes binding. So if there is a government authority which has submitted a claim, the claim has been considered in the resolution plan, they are bound by it. And if anybody has not submitted a claim, then Supreme Court judgment in Ghanshyamdas case of clean slate will apply. Nobody can come later on and say this was my claim if he has not filed a claim earlier. So to that extent, the new management is protected. There have been cases by the government authorities and they have been rejected by different high courts and Supreme Court.
But sir, this is where the rainbow case comes in, no? Where which has added to the confusion.
Rainbow, the recent judgment Supreme Court has clarified, and that earlier decision is not applicable to all.
Sir, in my case, there are about 10 subsidiaries of the CD which were not in CIRP. But those CD, because of non-filing, those subsidiaries are struck off. Though there was no business in them, nothing, but their subsidiaries were in existence, but they have been struck off as per ROC records. So now my query is, sir, do we need to revive those and update the filing, or you can sit on it? Because tomorrow ROC comes and says that you have to, because there have been cases where they picked up struck off companies and imposed huge penalties on the management as to, since they were not updated the filing, so penalties have been levied. So in our case, since we have now joined the management, now taken up the management, can that liability come on to us if we don't revive those companies?
You see, your liability for the previous deeds will not be there. Those companies have been struck off.
They are struck off, sir.
Do you need those companies to revive?
No, we don't need them.
Is it part of the resolution plan?
No, we have not said that. We've said that we will do the filing, but no penalty should be imposed on us. We will update them. And actually
filing for what? Filing for the subsidiary.
Subsidiary.
Does the subsidiary have any asset?
No, sir. There are no assets.
Then why you want to revive it?
Because there have been instances where ROC has stood up and sent notices saying that these companies were stuck up because of your non-compliance, but you are liable to pay penalties. So they have.
Section 32A protects you for all the past non-compliances. If it is not part of your resolution plan to take over those companies, why do you get into trouble with that?
Well, my view, but
I'm telling you based on the details which you have provided, the facts of that case will decide what you should do. But otherwise, you are protected under Section 30.
Thank you.
Sir, I have a query.
Yes,
one RP has filed application under Section 66 for fraudulent transactions, and Honorable Adjudicating Authority allowed the application. There is a recovery. There is a criminal prosecution also for suspended directors. So as per IBC, criminal prosecution is to be taken by IBBI. Now that has been intimated by the IRP. Now, what about the recovery of X amount that is to be taken from suspended directors? the necessity time, stipulated time in the order has already lapsed. So, and COC has not given any directions for content. Shall IRP file application at her own?
The PFU application is filed by the RP.
Yes,
After
yes,
the
of course.
orders, it is the domain of IBBI, because under section 236 subsection 2,
Yes.
IBBI
That is for criminal prosecution. That IBBI will be taking. What about the financial commercial part? That recovery is there. That he has to contribute to the assets of CD.
when he is not giving the recovery, what will you do? What course of action you have?
That is my query. Is if content application can be filed against those ex management.
That has to be routed through IBBI section 236.
Okay. Even that too under section?
236(2).
That also 236(2). Okay.
Even for section 19 subsection 2, application non-cooperation, when the NCLT passed orders and they don't comply with it, it goes to 236(2) for criminal action offenses against under the code. So that's a very slow process. Again, it is like civil courts. So it goes on for a very long period.
Okay.
Ashish
Sir,
ji, your time is over.
Sir, in one of my 2 cases, where I got the scheme approved, sir. And I also filed INC 28, but the MCA portal, they are not removing the status from the liquidation process status, they are not removing. So due to this, I am unable to induct the new directors who have given the plan during the liquidation. And in this respect, I have sent mail to IBBA as well as to MCA. ABBA telling that to go and meet the ROC. ROC is telling that please go and meet e-governance. Finally, I got the e-governance that you please go to meet ROC. So like this, more than 6 months has crossed. How to solve the issue, sir? How the liquidator to come out of this process?
Yeah, that's a problem being faced even in voluntary liquidation at times. I remember somebody suggested that you file Form 2 and INC 28 as an attachment to Form 2. That
Form
is
2
taken.
of Form 2 of which, sir? Form 2 under which?
MCA.
Uh.
See, when the CRP takes place, you are filing everything under Form 2. They are not allowing the normal.
GNL2 you are telling.
That is GNL2.
Okay. Yeah.
So just try with that.
Okay.
That this is the problem being faced by many.
The existing ex-promoters, they have to come out and new directors has to get in, no? So we are facing this issue.
These are all the practical challenges which RPs have, and unfortunately the government authorities which are supposed to help are creating more problems like the ROC.
Thank you, sir.
The right hand and the left hand do not work in tangent.
Yes.
They don't want for their interest.
Sir, my question is, can IP, ICICI, IP or all the IPS can be a help for that?
What did you say?
I said the IPS can be a help on that for coordinating with the ROC and other authorities.
ROC is a big boss.
ROC is a big boss, but what IP is doing, IP should help their members, na? There is one of the member, RP liquidator. He is not able to file his form for INC 28 for last 6 months.
See, these problems only the government can help. And if they take a holistic view about the problems being faced, see what the IPS can do is they can bring it to the notice of IBBI, and IBBI can take up with the ministry.
Yes, at least code of conduct is there. They are the one who is watching us, so they should help us. So they resolve at least these issues.
Yeah, the demand is very appropriate, And that's how the lot of IP associations should also do the work. They should bring it to the notice, because you see, the government wakes up only when you bring the problems to their front.
Yes.
And you have to persistently follow it up. Simply making a complaint will also not help. So, any other questions, or we close the session?
Like this, no, many areas we face issues.
Sir, I
If
have a
some
point to
nodal
make.
officer,
Would you like to touch upon the PG to C cases?
One at a time. One at a time.
Sir, I have a point to make. Could you please touch upon the personal guarantor to corporate debtor scenario? Like, I mean, the practicalities, practical issues being faced there, and also given the jurisprudence of the Supreme Court in that area. Would you like to comment upon that, sir? Thank you.
If you have a specific question, I'll be able to help, because it's a subject
So
in itself.
being specific question is the interest of the IP is not getting protected. I feel so. When the NCLT, I got an assignment recently from NCLT. So in the order, they haven't mentioned any fees part of it. It's like a work which we have to do, and there are lots of issues around it. So the CD has already been liquidated, and banks have got some amount realized already, but they have submitted their claims running into hundreds of crores, but there is no ray of hope in terms of repayment plan. So these are all the practical issues. So would you like to touch upon this, please?
I'll just like to give a brief comment on that. The scenario regarding amount or quantum and payment of fee is much worse in individual insolvency than the corporate insolvency. The rates are very low, and in fact, our IPs are to be blamed for that. Some of the IPs are taking cases for 35,000, 50,000 a case, when a normal staff in your office will not be available for less than 30, 40,000 rupees. So the whole problem is contributed by us in a way. If we resist taking assignments at very low fee, the market situation will improve. But many of the forums I have seen, people who will advocate for good amount of fee, they themselves give quote for low fee. So that's the reason, because we are part of the same economy, same system where governance is lacking. So that is all the case among the IPs. You can't help that. It's a market-driven situation. When people are available to do work for lesser amount, they will be appointed. And the scenario is very, very, very disturbing as far as
This is further disturbing when we have to, when we are bound to accept the assignment when it is coming through the NCLT panel route.
That's why I have not got this empanelment after the first year. And many of the people have dropped the idea of getting empaneled. And that's what I say. We advocate about the free exit of the business entrepreneur, but we don't have free exit for the professional.
Sorry, when you said you are not getting, you are not going for empanelment, is it with banks or with NCLT?
Either banks or with the IBBI.
Okay.
Because even if you get empaneled with the banks, it is not necessary that you get an assignment. You will get hundreds of emails. You will give the bids, but you know how it is decided.
Yeah. It's a one-way street. The black box, lock box.
These are the realities, and we talk a lot about ethics, honesty, integrity, and transparency.
I have a very peculiar case in this with regard to an appointment by NCLT Allahabad.
Okay.
It was by an operational creditor, and the COC had a stake of just 2 lakhs as repayment of loan.
Okay.
None of the COC meetings were attended by them. I filed an application for 19-2 dissolution as well as for cooperation by the COC. All the 3 are being listed for the last 3.5 years. No adjudication given. No adjudication given. And I am paying, and my fee is getting accumulated. My fees is freezed. I called it, I kept it for only for 6 months. But for 3.5 years, I'm following up the case to just get one simple order that it is dissolved or anything of that nature. Nothing.
So the only thing I'll suggest to you is that you open the website of NCLT, and when you open the NCLT website, the first thing will appear is the Prime Minister's brief clip statement. NCLT is doing wonderful work for the corporate governance in the country, and you enjoy.
That's what I do it, sir. As I said in the first point which I said, it's a satire.
Yes.
You have to be with the satire. That is what.
In one of my case, I asked the judge that please clear my dues. मतलब वो बोल date दे रहे थे. He was giving date to someone. मैंने कहा सर date तो दे दी but पैसे भी दिलवा दो. My money is pending. So he told me that who are you? I could not understand his question. मैंने कहा sorry sir, who are you? मैंने कहा sir RP. You are the government of India. Okay, sir. And who is against you? Sir, Income Tax Department, who is also the government of India. You both are brother. Decide yourself. Why you are wasting my time? This was I could not say anything, but just this was happening in the court. That you need money, you go to your big brother and ask. Now, after 3 years, I got an order to appear in person, the Chief Commissioner of Income Tax. But still there is no response.
True. At least you got the solace that you are government of India.
Yeah.
So thank all of you for interaction.
Sir, your government of India without a car of red light.
वो तो उनको भी नहीं मिल रहा है अभी. It is very selective.
सर यही गवर्नमेंट ऑफ इंडिया की पहचान होता था ना पहले.
No, it was a question of status.
Yes.
Lal Batti.
Yes. He is in the
Very.
No.
Lal Batti.
So means IP wants Lal Batti. That's what the.
Thank you, Madhu sir, for sorry to interrupt in this interesting deliberations that were going on, but
Yes,
with your permission, can we close this session?
Thank you very much.
Sure.
Thank you.
We also want to have lunch, madam. Yes, you can close.
Thank you.
So
Thank you.
formally, I would like to place vote of thanks to our faculty, Madhu sir, who have interacted with all the participants with so much of energy since morning for these 3 hours. And I think these 3 hours have set up the tone for the rest of the weekend, and we can enjoy such good weekends with the rains across the country. So thank you, Madhu sir. Thank you so much for giving us your time. And it's been a wonderful these 3 years to learn so many things about the topic. Thank you so much, sir.
Surbhi, there is a session after lunch or only?
No, sir, we have only 3 hour session for today's workshop.
Thank you.
Sharma, thank you so much for nice deliberation.
Madhu sir, thank you very much, sir.
Thank you.
Thank you. Madhu
Thanks
sir,
a lot.
thank you.
Thank you, everyone. Thank you.
It was really nice session.
Thank you.